Good afternoon, everyone. My name is Michael Pastor. I'm the director of the James Tricarico Jr. Institute for the Business of Law and in-house counsel, and I'm a professor from practice here at New York Law School. I wanted to welcome you all to our webinar, Navigating the AI Revolution, Essential Insights for In-House Legal Teams. Super excited about this webinar, the people we brought together that are going to go through this vital topic with you all today. This event is co-sponsored by New York Law School, which is where I am, and Cimplifi. I wanted to thank Cimplifi upfront and the Cimplifi team, particularly Jill Brown, for just immense help that they've given in setting this up. And before I introduce our speakers today, I wanted to turn the floor over to Steve Harbour. Steve Harbour is the executive chairman at Cimplifi, a proud graduate of New York Law School, and also a member of the advisory board of the Tricarico Institute. Steve, over to you.
Thanks, Michael. Again, as a proud alum and supporter of the school, thrilled to be able to be part of making this event happen. So excited to follow the work that Michael is doing to prepare law students for the new world of law that they're going to be entering upon graduation. And so we'll keep it short and pass it back to you, Michael. But again, really happy we've been able to put this incredible panel together, and looking forward to hearing the discussion.
Thank you so much, Steve. And with that, I'm going to share my screen to put our speaker bios up. Okay, here is our fantastic set of panelists. Before I introduce these panelists, you'll note at the bottom of this slide here an important disclaimer. These panelists are here to express their personal views and opinions on the topics we are speaking, and they are not here representing the employers that they work for or expressing their views on behalf of those employers. With that, here are our panelists. First, we have Haley Littman. She's a counsel at Jane Street. She's an adjunct professor here at New York Law School, and she is an alum of New York Law School. We have Ashley Pristakis, Senior Manager, E-Discovery and Legal Operations at CrowdStrike. We have Julian Thiessen, Director, Global Legal and Compliance Technology at Meta. And we have Chanu Joseph, Product Counsel, AI Legal at Salesforce, an adjunct professor of New York Law School, graduate of New York Law School, and a former colleague of mine. With that, we're going to kick it off. Here's going to be our format. I'll be moderating the discussion among these great people for about 40 or 45 minutes. After that point, we will turn to the Q&A in the Zoom to look to see if there are any questions from the audience. Stop my share there, and I'm going to start us off with what I think to be a very important introductory question when we're having these discussions. What are we talking about when we talk about AI? So let's define the term. What's the most useful way for us to be framing the idea of AI before we jump in on our discussion? Ashley, do you want to start us off?
Sure. Yeah, first I want to say thank you for having me. Looking forward to the discussion today. So I think what's most helpful here is defining it and putting, context around the concept. So starting with the history that, AI is not a brand new concept. It's been around for 60 plus years. And with the continuous evolution of AI, today's focus is really going to be on the explosion and the hype of generative AI. And to, again, put a definition to that, ultimately a type of AI capable of generating human-like output. It can be text, it can be images, it can be videos, and then other data using generative models. Often it's in response to prompts. So I think we'll also discuss some definitions around that. And I think the newest AI technology, it goes beyond, right, the keyword searches that we're all used to in Google and other formats, and also beyond, AI that we're used to that's just machine learning. This is generative AI that is incorporating contextual concepts and understanding the ability to review that output and iterate on it.
Do you want to add anything there? Any others in the panel?
One other thing is, like, with the concept of generative AI, there's a subset of groups of providers that are called like LLM providers, large language models, that is created by these providers. Namely, the most famous one is OpenAI developing ChatGPT, which is an LLM model. And through the wide disbursement of like this technology, a lot of companies are building on top of these LLM models or incorporating it into their technology. And there has been more a trend using these LLM models and stacking this technology on top of it to provide more fine-tuned or more narrow use cases to fit your business needs. And that's where we're trying to analyze, like, how can we use it in in-house areas as well as for specific companies or industries.
Excellent. My thanks to you both for that setting of the table. So now let's turn to topic number two, which is in some respects why we are doing this webinar altogether, which we want to talk a little bit about use cases. How are these tools being used by legal departments and by in-house lawyers? So let's jump in there. Julian, can I turn to you to start us off talking a little bit about some use cases of AI in the legal department setting?
I'm speaking on mute. My apologies. You know, the one of my favorite expressions about artificial intelligence, which I use every time, and it's a good example of this, is that artificial intelligence is no match to natural stupidity. That's what I just demonstrated here. I was speaking on mute without even realizing. Michael, I'm sorry. Do you want to present the slide that we have? And while Michael presenting I want to start by saying that we are all learning. There's no sort of standard sets and standard terminology yet when it comes to these use cases, specifically within legal industry. And if I were to draw an analogy, I feel like we are with generative AI today where we were with e-discovery 25 years ago. It was a bit of a wild west, those of you who remember, until the industry came together and came up with standard frameworks, terminologies, and so on. We don't have that yet, so we all sort of inventing this on our own. I expect the industry to come together in a couple of years, but for now we need something. So the terminology you'll see on this slide is mine. Feel free to use it, but it doesn't mean it's correct. It doesn't mean it's gospel. It may change tomorrow. So with that, I will kick this off. I like to have frameworks when I talk about this sort of different use cases, and I came up with this sort of a two-step approach. The first one, you see things in blue and green, generic and grounded. So we have the way I look at this, we have two big buckets of use cases, one generic, one grounded. So what do I mean by generic? Generic is the type of use case where we go to a large language model and we ask a question or we provide a prompt and we expect the model to provide the answer based on the knowledge it acquired during its training. So the example for GPT, for example, GPT was trained on incredibly large amounts of data. So it has a lot of information already built into it. So if you go and interact with ChatGPT, you are being in this generic bucket, if you will. You ask a question and GPT or another large language model will reply, again, based on the knowledge it already has from its training. So that's the first bucket, generic. The second one is grounded. And the reason why I called it grounded is because there's this notion of we can ground the model in a specific document or a set of documents. So think of it this way: you can upload a set of outside counsel memos if you would like to, and then ask questions against those documents. So in that case, the model will reply with answers that it finds, with information that it finds in those documents, and that's different, right? Because those documents could be very proprietary, and those documents were not in the training set that was included in when GPT, for example, built its model. So I hope that makes sense at a very high level. And then within each of those buckets, we have different sort of subtypes, if you will. I'll start from the very top, brainstorming. This is, I think, one of the less known or at least less popular use cases for some reason within legal specifically. And I think it's a mistake. I think it's a very powerful use case. It can help you with a lot of sort of ideations. It can help you with this kind of a blank page syndrome when you don't know, you have an idea, but you don't know how to express it yet. Ask a model. When you ask the model, it will come back to you with something, and it's not going to be a good quality initially, but it's a very good first step where you can start your drafting. The second below is what I call authoring. I kind of start talking a little bit about it, and you'll see I put both generic and grounded because depending on the use case, it could be either one of those scenarios. Imagine a scenario where you just want to start writing about a topic that you know nothing about. You can just go to the model and ask a question, and then it'll come back with something. And it will come back with information from its training set, as I mentioned before. That's the generic use case. Now, on the flip side, imagine a scenario where you want to generate an outline for a PowerPoint based on documents that you already know, that you already have in your possession. Now, you can upload those specific documents and then prompt the model to generate an outline based on the information in those documents specifically. So this is why authoring can be either generic or grounded. And then if we go down the list, I'll go to the very bottom. Actually, I think it's more important right now is what I call interrogating documents. I think that's probably 80% of the use cases you hear today in the legal industry. The idea is very simple. We all live in documents. Documents are our widgets. That's what we produce. That's what we use a lot. So obviously, there are a lot of use cases where we want to ask questions against those documents. You can think of it as next iteration of search. Now, we used to be able to provide a few keywords, maybe do some semantic matching, and as a result, from search, we'll receive links to documents, so documents back. And then you're going to have to go read those documents and find the answer to your question. What large language models can do potentially is to synthesize that answer for you based on the prompt. So imagine a scenario where you have let's say 50 memos from outside counsel on a particular topic, let's say on a EU AI Act, and you have a very specific question. You can upload those documents and then ask the question. The model will find the answer, will generate the answer from those documents for you. And the answer could be in any format. It could be just a distinct answer. It could be a memo that you want to write, a summary of those documents and things like that. So that the document interrogation is a very popular use case, very powerful use case. And again, it goes from one document. You can just upload a document. So one of the things I mentioned to our panelists when we prepared for this is that when EU AI Act was passed, it's a document of about 400 pages. I uploaded the document to the tool and started asking questions against that document. First, I wanted to get the summary of the document, just to get a lay of the land, if you will. And then based on that, I deep dived into the document by asking specific questions and getting answers back from the document. And depending on the tool you use, the better tools will provide citation to everything that the model outputs. So you can quickly click on a citation. It'll be taken to a portion of a document that discusses that particular topic. And that's how you can sort of double check the quality of the output, which is an important topic that we'll need to talk a little bit about later. One of the use cases I'll mention very quickly, well, two actually. Summarization is a very, very powerful use case. Again, if you have a document or a set of documents and you want to create a summary, you can ask to summarize that set of data and get the responses back. And the other one is translation, which was somewhat surprising, to be honest with you. We all knew that these models can do translation, but the quality of the translation is really, really good. Now, I wouldn't call it sort of a legally certified translation, but it's good enough for probably 80 to 90% of use cases. And that speeds up the process a lot. One quick note on the last bucket that I didn't mention is that all of the legal research use cases that you now see pop up from Westlaw and LexisNexis and Casetext and VLEX, they all fall in that bottom category. The difference is these vendors provide that predefined set of documents to ground the model. And that's obviously a very large set of documents, all the opinions and case law, but conceptually it's the same thing. There's a set of documents, in this case, millions of documents. When you ask a question of the model, it will go into that set of documents and provide the answer from that set, not from the training data that the model was trained on. I'll stop here if anybody wants to jump in. Oh, and one thing, sorry, I didn't mention, there's this notion of hallucination, which we'll cover a little bit later. The one thing I want to show here is that hallucination increases, the risk of hallucination increases as you go from grounded towards the generic set.
Thanks for that. Super helpful, Julian. And you just reminded me of a conversation I frequently have with law students where they say, do you think I should go in-house someday? I'm interested in X topic. I'm interested in sports and entertainment, which I also always like to say, are you interested in documents? Do you like reading? Do you like working with contracts? Because if you like that, you're going to like whatever field. And it's interesting to see your slides sort of bring out how AI is going to be doing, besides us, what we as in-house lawyers have always been doing. Haley,
Michael, I wish you were my law school professor, because I would have enjoyed that advice.
Yes, we try our best. Haley, did you have anything you wanted to add on the use case field here?
No, I mean, I'll just quickly mention, I think Julian did a good job sort of describing the various use cases. And I think there are a lot of AI tools to support legal generally. And I think as an in-house counsel, maybe assessing some of these tools, you want to think about ones that are more geared for in-house use, working with contracts, working with template drafting, and sort of understanding, as we'll touch into a little later, how these LLMs have trained their models to be more reliable, and trained on more legal resources as opposed to sort of what's available on the internet. But I think they are very helpful. They create efficiencies, and there should be sort of more of a welcoming than a resistance to some of these tools, because I do think there's a lot of great benefits.
Absolutely. And I think that's a question that overrides this entire conversation that in-house lawyers will have, which is, should I be using this? And hopefully what you're going to draw from this conversation is a lot of benefits you can get from using it. So I want to turn to Ashley now. I think that the focus on e-discovery and legal ops is sometimes not as strong as it should be, given how closely linked that work is to the work that in-house lawyers do. Ashley, can you tell us a little bit about the Gen AI use cases in the legal ops and e-discovery space?
Yeah, of course. So kind of borrowing what Julian had shared, I think almost everything that I envision being used within legal ops and e-discovery fall into one of the buckets that he described. These are a little bit more specific in terms of like the day-to-day tasks I envision that a legal operations or an e-discovery specialist might use it for would be things like summarizing or ideating on, how the best how to best handle a certain task, right? Or, you're taking furious notes during a meeting, and you look back at it 2 days later and you're like, I need to make some sense of this. Throw it into a tool and it can help you organize your thoughts. So I think the day-to-day is one use case that's off the bat going to be helpful for team members. But I think the broader project-driven type things in legal ops and e-discovery, I think specific to e-discovery, a 1L first level review for large data sets that you've culled as much as you can. Within a document review, you're already developing a protocol for your document reviewers. I think there's a lot of opportunity out there for tools to embed that in their already driven workflows and apply. What's going to happen is the Gen AI tool will use your input of your protocol, and you're going to have to cull it down and iterate a bit, right? Just like you do with search terms anyway, and other analytics that you're riding through with e-discovery. But you're going to apply that to the document set. And I've heard amazing results already in the industry with this, where people are seeing major cost reductions and resource and time. I think some other operational use cases are specific to the summarization and probably mostly falling under that interrogating documents. It's really making sure that you have a high trusted source of content that you're looking to either create a chatbot against, or, literally just having like a knowledge management source of information, whether it's policies, whether it's, whatever it might be. You have to have a high trusted source of information and then apply the generative AI to it, and learn the best way to prompt is just by practicing with the tools and asking the content questions. What is our retention policy for XYZ? What is, what's the policy on global travel? And you get good responses versus having to maybe enter a ticket and have someone answer that ticket manually. I think another, the last one I'll mention is actually ticketing, is, trying to understand in-house, who do I go to figure this out? Or I have a question on an IT item or a legal or an HR item, being able to go to a tool and instead of entering a ticket, have the ticket either entered for you based on your question, or being able to identify the right workflow so that you can put in the information. So those are just three, high level use cases that I envision being something that can be deployed and implemented fairly quickly.
I can add a couple of examples just to kind of provide the breadth of this a little bit more. So as Ashley mentioned, knowledge management is a huge area of concern, I think, for a lot of large legal departments. We're sitting on a lot of IP, our own IP that we produce, but also IP that we purchase, like outside counsel advice and things like that. And historically, large legal departments, specifically large legal departments, were not very good at storing that information correctly and investing in proper document management systems and processes and things like that. Now, there's no sort of shortcut. You still need to get all that information into one place, but you can now use that information a lot better with these with this model. So the big example that I hear all the time is the outside counsel memos. We're sitting on thousands of them. We've paid a lot of money for all of that advice. But because of the size of the department, people next door to me may not realize they've already asked that question of outside counsel, and they may go and ask that question again and again and again. So being able to find that information, not just find the documents, but actually get an answer from a document or a set of documents, as I mentioned, is very important. Another small use case, but I think it will be very efficient. I haven't tried it yet, but I've heard about it, is that, again, very specific to legal department, is that we are processing thousands, if not millions of invoices, right? And those invoices have to be reviewed. And today it's a relatively manual process. There's a way to analyze those invoices against your own specific billing guidelines that you've agreed to with the law firm automatically and identify issues that way. It's a very narrow space, but it shows that even like a little bit of efficiency gains could go a long way. And speaking of efficiency gains, just to be clear, and I hope everybody on the call understands, that there's no magic button. There won't be like, we're not replacing lawyers, at least not in 2024, not in 2025. I can't tell you what happens in 2026, but for now we're not. So this is the efficiency game for me, at least. So if we can gain 20 to 30% efficiency, that's more than enough to justify whatever investment we need to make into this technology.
Great. Yeah, I will add to all of those points by saying, I touched upon this on the article I wrote earlier this year in the New York Law Journal. When you're in-house, what you're thinking about is not just the quality of your work, but is the morale good? Are people happy? Because I feel like people that are happy do better work as a general principle. When we have inefficiencies, we're talking here about the use cases. When we have inefficiencies, those grind down on people. They grind down on teams. And so sort of taking away those friction points and then kind of aggregating all of that over time, you really see the potential. I will say that when I was sitting as general counsel, yes, AI was around, but it was not nearly as hot as it is right now. And I don't really remember having conversations, but if I had the time at the time, that ability would have been so powerful to say, I see some inefficiency. For example, inefficiencies in calendar management, inefficiencies in the way appointments are set up, inefficiencies in the way meetings are held. All of those things, just getting rid of those could be huge. Did anyone from the panel have anything more they wanted to add on here as it relates to use cases before we move on?
Maybe I'll add one more note. Sorry.
Great. Go ahead.
It's really just a high level sort of theme, and I think it's important for everyone. At least to me, it was a bit of a learning curve. When we normally evaluate technology, and my background is I'm both a lawyer and a technologist, right? So when we evaluate technology, we have a relatively straightforward path forward, right? We basically we start with the problem. We identify a problem, and that's what everybody will tell you. Don't start with technology, start with a problem. Identify a problem, figure out the requirements, then go out there, identify technology that can potentially solve the problem with a set of process and so on. And that's what we're doing here. But on the flip side, we also don't know the capabilities of this technology. So we're sort of like, well, we know what the problem is. We can apply the technology, but we also don't know what other problems this technology can solve. So we're still at that point where we're researching and trying to understand. So the list of use cases will continue to grow. Every day I hear somebody come up with a new use case. So going back to my initial kind of disclaimer, don't take this as gospel. Things will change tomorrow, literally tomorrow. If you follow this space, you will see additional use cases popping up daily. So just stay tuned and continue to learn.
I agree. And I'll just second that point, Julian, by saying, one major theme that we hit a lot in the Tricarico Institute here, training future in-house lawyers, is this concept of continuous improvement as the lawyer, like getting better all the time. It's nice to sort of be pairing that now with the tech, because it used to just be we are constantly improving, but the tech is either not, or even worse, our legacy systems are becoming a problem for us because we haven't updated things and we haven't patched our system. Now this notion of we improve as the tech improves, it's rather exciting. All right, with that, I'm going to turn to our next topic. We wanted to touch briefly upon what is out there in the regulatory space. I'll start by saying, sometimes you will hear people say, well, there's really nothing out there yet on regulation. And I think that may be true, particularly in the United States. It might be a fair assessment, but as you'll hear from Chanu and Haley, there is a lot that we need to look at And I'll go through the EU AI Act a little bit as well, because it's out there and something for us to be thinking about, even if we don't, have company doing business in the EU. With that, I'm going to start with Chinu. Can you start talking a little bit about the regulatory landscape?
Yeah, of course. I'm of the opinion that I would love a one size fit all type of regulation and framework. That was my position with all the US privacy legislation. I was kind of envious of the GDPR where they had that kind of framework set in place. And I'm hopeful that we have that eventually in place with all this like AI regulations that's coming down the pipeline. Like I mentioned, there's not a one size fits all overarching federal US AI regulation in place yet, but there's like executive orders that the president has signed. There's state and industry regulations. There's also a lot of risk frameworks that's been published. For example, the NIST AI framework is something that I follow and track against. And there's other guidelines that keep popping up. So, this is going to be an ever evolving industry. With that, there's going to be a lot that comes into play in terms of assessing the regulation that needs to be coinciding with this advancement in the industry. But I do want to say there's been some common themes amongst all these developments, right? The focus is on risk-based approach. And I want to take it back to law school. This is one of the first classes I teach in the semester for the class. So it's like analyzing legal risk, right? So that's the central theme in all of these different AI rules, regulations, and industry-specific guidelines, like trying to mitigate the risk as much as you can and restricting some high-risk activities. So for example, do we want AI systems to provide us with medical advice? Do we want judges to input data, input all like briefings and ask the AI system, well, should I award summary judgment? These are highly impactful to end users. And we want to kind of put all these parameters in place to mitigate that risk. So in terms of the upcoming guidelines and stuff, like and industry specific rules, I would just look into what's prohibited, in terms of risk assessment, what is trending towards high risk activities and how can you mitigate that? How can you add a human in the loop? How can you add disclaimers? How can you put things back into a medium to low risk category? So that's pretty much what I've seen across the board. And I think Haley's going to discuss some other industry specific nuances.
Yeah. Yeah, to piggyback off that, I think, as in-house lawyers, we understand who our regulatory bodies are. And I think a good starting point, if you're unsure of, okay, what regulatory framework should I be thinking about or should I be following in my role, think about who your regulators are. FINRA has guidance on artificial intelligence applications in the security industries. And there's various guidance like that you can look to get a sense of where your regulators are going if you're going to need to eventually respond to any sort of investigatory requests, or how are you using AI in your firm? And you may want to start thinking about policies and procedures. But I think just sort of identifying who your regulators are, seeing the sort of guidance that they put out, and then executing a game plan from there is one good way to start grappling with the sort of unknown regulatory framework that currently exists. But that is evolving.
Excellent. And let's talk a little bit about the rules that are applicable to lawyers. Julian, can you talk to that issue a little bit?
Yeah, sure. So as we all know, most of our work is governed by individual state bar associations' rules of professional responsibility and conduct. And most state bar associations came up with specific guidance and opinions on how to use this new iteration of AI in our day-to-day work, our legal work. So first of all, I would encourage everyone to look up their own state's guidance on that. I think most of the bar associations came up with those guidance. I can tell you, I'll look at the ones from California and New York. They're very similar. They're structured differently, but they're very similar. And at a high level, they all say the same things. We have rules of professional responsibility. We know those rules. Let's just not do anything stupid and let's follow the rules, even in this new brave world of AI. And I really like the one from California, not being biased, but the one in California created a very specific table where they've listed the specific responsibilities that they think might be impacted by the work with AI. And they applied AI sort of use cases to the individual responsibilities around duty of confidentiality, competence and diligence, and compliance with the laws and supervision of attorneys, communication, and so on and so forth. So it's a very simple guide, and I think most of the states basically say the same things around how to use AI in our day-to-day work. Now, stay tuned. There's some, I've heard that ABA is trying to come up with something as well. I've heard that there's a draft. I don't think there's a sort of a countrywide approach yet. So just stay tuned. It's still a very early days.
Thank you for that, Julian. And what Chanu and Haley, what you all just went through there reminding me of something that came up a lot in the cybersecurity world, which is that just because you're working on the cutting edge of technology doesn't mean you have to not rely upon all the classic things you as a lawyer would have done, in the past. And I really think that comes up here with AI as well. I mean, we're talking about some really just fast breaking, brand new technology, but a lot of all of what we've already known and learned is going to be of use to us here. With that, I'm going to take us just through a couple points on the EU AI Act. I thought it was worthy to hit some high points about that. Obviously, as Julian said, it's 400 pages long, and I've just decided to discuss 3 things. So it's a real short thing, but I did want to call out a couple pieces of the act. First of all, it's a rather broad and intricate definition for what this is. AI systems are defined as those that infer from input that they get in how to generate outputs, so predictions, content, etc., that can, and I quote, influence physical or virtual environments. And that definition alone, I think, is going to present some really interesting questions for in-house lawyers, particularly on the question of what does it mean to influence a physical or virtual environment. I'm not going to answer that today. I'm just going to tell you it's something that we should certainly be thinking about. Point number 2, there's extensive risk ranking and risk classification. This goes back to Chanu's point as well. The regulators there have listed out high-risk systems, so you'll know which one you're in depending upon what you do. I think it's a really good starting point for someone approaching an AI project. Say, what type of data are we dealing with? What are our risks that are in play? I do think risk classification work out of data privacy and cyber, it's going to have to come into use for you there as you do your AI work. And lastly is the definition of the roles. And here I'm talking about the organizations. It's going to put in-house lawyers, at least if this act is applicable to your organization, in that role again of thinking, what are we? What is this organization? What do we do? What might we do? And some really interesting legal questions when you maybe fall into 2 different buckets. So that's my EU AI Act in less than 60 seconds, but it is, I think, a worthy thing for us all to be analyzing, given its import both in Europe and here. All right, so we've talked a little bit about use cases, getting the regulatory framework. No discussion about AI is going to be worth your while unless we talk about risks as well. So what are some risks here that are worth thinking about? How do we think about those risks? Let me start with you, Chanu, on that.
Yeah, generally I want to talk about the natural risks associated with using artificial intelligence, right? These tools mimic human intelligence, and there's that notion, as you mentioned, of inference, making an inference. I'm not really sure how you, Michael, make inferences, and it's hard for me to predict that. And like the AI systems, because they're fed so much data, it's hard to predict what type of inferences, hence outputs that it will provide. So when considering how to use and deploy AI systems, here's some issues worth considering. It's mitigating a lot of the inaccuracies and ethical risks. For example, testing for bias, constantly testing the system is something that, what I've seen across the board as something that to mitigate this type of risk. There's this concept called red teaming. I know my industry employs it, where a lot of the ethics and data scientists actually go in and before it's deployed, constantly test the AI systems and the use cases, right? So they're trying to mitigate and protect against harmful outputs, harmful behavior. They're putting kind of meta prompts in place that kind of limit what type of outputs and parameters that can be generated. So if I'm saying back to that example of a judge creating a summary judgment, there might be a flag that comes up as an LLM system, I cannot provide legal advice here or make legal determinations, right? So those are some of the ways to mitigate that risk. It also, some of the risks include leaks of sensitive behavior and generated content that's maybe toxic, biased, or factually inaccurate. There was a couple of examples in the press. There's always examples in the press where they ask for a doctor and it kind of, paints the picture of a male, and they ask for a nurse and they paint the picture of a female. So there's those nuances that that is worthy of mitigating that risk. And in addition to mitigating ethical risk, it's always important to evaluate acceptable use case scenarios. These LLM providers have a list of acceptable use cases in addition to regulations, right? If you look at all these LLM providers, it's pretty lengthy of what you can and cannot do with the LLM provider. So carefully reviewing that will mitigate some of the risks and protections that you'll receive, as well as assessing the risk versus benefit. And then also incorporating concepts by privacy by design, making it very transparent. This is a generative AI system that, and having a human in the loop. That's avenues by which you can kind of mitigate those risks, where you are abundantly clear in terms of transparency, obtain consent before putting in data, feeding that data into the LLM, as well as having a human in the loop to review the outputs. Like, instead of just taking that output and shipping it out, like having someone in there to actually review the output is very important.
And you remind me, Judy, I mean, given the amount of time that I as GC would spend before sending something out to the world to make sure it said what I wanted it to say, the thought of handing it to an AI tool and saying, you send that out tomorrow, is just something that does not even compute in my mind. Haley, did you have anything you wanted to add on the risk evaluation front?
Yeah, I think I want to note just generally too, when we talk about risk and some of the other things we'll touch on today, like when it comes to contracts, I think the approach, you should be assessing the tools you may be using in your own in-house capacity in the same way you're assessing deals that you may be working on to bring in LLM type offerings to the firm. And there are things that you can do to mitigate risk. Obviously, from a contractual perspective, we'll sort of touch on some of the terms you can put in place with these LLM providers to ensure data security and ownership and other things like that you may be concerned about. And I also think understanding sort of the technology that you're contracting for and how the LLM works and how it's been trained, and doing that sort of due diligence process can help mitigate risk. And if you are an organization and you have your own enterprise contract with these big LLM providers like OpenAI or Anthropic or Google, you may have the ability to do something called bring your own key, and that will allow you to securely utilize data in that LLM while that data is being subjected to the terms that you've contracted for with those big LLM providers. So there are some nuanced, technical things you can put in place to mitigate risk, but it does come with taking the time to understand the technology, understand how your firm is using LLM providers going from that route.
Yeah, well, thanks, Janu and Haley, for that. And I'll only add to that point, good in-house counsels don't become overwhelmed by risk. So that's the fine line again, where we're identifying all these risks. But if you're overwhelmed by risk, then you can bog down your client. So let's talk about two specific risk buckets: data integrity, data quality, and hallucinations. I'll turn to Ashley and Julian to cover those two topics.
I can start things off, and those two topics they're separate, but they're very related. Now, we specifically, when we talk about generative AI, large language models, we have sort of two types of data, if you will. And if you go back to the use case slide that we talked about, there's this generics bucket and the grounded. So generic is what the model was trained on, and usually we have no control over that. So OpenAI decided to train its model GPT on certain types of data. They've trained it. We are as users and consumers of that model have no say into the quality of that data. We get what we get. Now, those large providers spending a lot of time, a lot of money on clean that data. Still, obviously, it's not perfect. But again, just to be clear, we have no control over that as consumers of it. What we do have control over is that second bucket of grounded use cases. This is when we, as a reminder, when we provide a set of documents to the model to analyze. Obviously, the old expression, garbage in, garbage out, still applies. And depending on the number of documents that you ground your model in, that issue will become bigger. If it's a one document, like when I analyzed EU AI Act, it's very difficult for me to mess it up, right? I upload the document and it's there. If it's 20 documents or 50 documents, there's a higher chance of putting the wrong document into your set, and obviously that will mess up the output. Now, if you connect the model to your data, to your document repository with thousands, if not millions of documents, you can see how this can become a very big problem very quickly if your document repository is not up to date. So if you have outdated versions, if you have documents that shouldn't be there for some reason, that will all creep into the analysis and obviously will produce bad results. So you need to be very careful about that. The issue of hallucination is probably the risk that was the most hyped when this technology was unleashed onto us. We've all read the stories of poor lawyers who used ChatGPT to do case law research, and then the model came up with some cases that never existed, and lawyers never checked that, and they put that into their filings. Obviously, a bad look for everyone. Just a very quick thing, hallucination is a very cute word. All it means is convincing lying when it comes to large language models. And I want to stress convincing. When these models lie, they lie incredibly well. It's very difficult to sort of catch them. So we need to be super careful. I'll give you one example. When ChatGPT came out, end of 2022 now, I guess, we sat together with a few lawyers and just kind of people that I know are interested in technology and kind of played with it a little bit. And I found an MBE question, a multiple choice question from a bar exam, and I put that question as a prompt, and I asked ChatGPT to answer that question and also provide reasoning behind the answer. And that answer, I'm not a law school professor, but I think it was an A plus answer. It found the right answer, and it provided the reasoning and the logic behind the answer. And we were all super impressed. I mean, we all had a bit of PTSD remembering, MBEs and bar exam, but the answer was incredibly impressive. So then I asked the model, can you find a case? Can you cite a case that justifies your position, your answer? And it found the case. It provided a full citation, federal reporters and everything. It provided almost like a explanatory parenthetical of why the facts of that case aligned very well with the question, which is what you would expect, a law school student to do as well. And then the last question I asked, can you provide, can you send me a link? Can you send me a URL to this case anywhere online? And first, I think it sent me a URL to Google Scholar. Some of you may know that Google Scholar has some of the case law, and it was a properly formatted URL. And when I click on it, it took me to Google Scholar, but I got page not found. I went back to ChatGPT and said, sorry, that link is broken. By the way, I'm always very polite when I talk to these models, just in case when they take over, they'll remember that I was polite to them. When I asked for another link, he gave me another link, and all the links were broken. And then I went to Westlaw to look for the case, and the case did not exist at all. But the way it described the case, the level of detail it provided on facts and how the facts matched the question I asked was just incredible. So we need to be very careful about this. Now, I'm not going to go to the detail. There's something called, if you want to impress your engineering friends, there's something called RAG, Retrieval Augmented Generation, which is a method of limiting the level of hallucination by focusing only on the documents that you provide, that grounded approach. The one thing I want to mention about it, you'll see a lot in the press that this is the method to eliminate hallucination. It does not eliminate hallucination. It reduces it dramatically, so we should use it, but it will never be zero. So just remember that and keep that in mind. When you get that first draft, you always have to check it, depending on the risk level and use case.
It's sad to say humans also are rarely error-free, no matter how hard we try.
Well, that's a great point. We'll talk a little bit about this when we talk about evaluation. Yeah.
Ashley, do you have anything you want to add?
Yeah, I'll just add in that, I agree 100%. You always have to have the human element in the layer of QC after any output. I mean, you want to make sure that the output is accurate. I think another piece specific to the data hygiene, you have to follow your best practices within the organization, retention policies, and making sure that it is not the only item. It's making sure that your data and your sources are up to date. And for some corporations, that's a huge lift in terms of preparing for, attaching generative AI to any of your tools or systems. Others, it might be an easier just a cleanup, but that is absolutely critical. I think another call out though is also the prompting. I think we can train and use these these LLMs based on what they've provided to us. But I think there's also an element to this. There's an art of prompting that we have to iterate and continue to iterate. And then as you're using the tools, you can even have personas or if it's, I guess, OpenAI calls them chat GPTs or GPTs, you can create your own to develop, the different personas or tasks that you're trying to achieve so that you're training it on top of what already exists that's been provided out of the box. So those are the only two add-ons.
Well, thank you both so much. Okay, let's turn to in-house counsel's bread and butter, contract work. Haley, Chanu, can you tell us a little bit about what key terms and conditions are coming into focus as it relates to AI?
Yeah, sure. I think there's some AI sort of specific terms that you want to think about when you're contracting. And then I think there's an application of existing terms and existing concepts that are going to apply to the way we think about inputs and outputs. So for some of the AI specific terms, training, most customers do not want the LLMs training their models on their data. In instances where, you're building sort of a custom model, maybe you do want the training, but I think the industry position has been that no training models, you can put contract provisions into that effect. Most of the LLM providers have that as a baseline that they will not train their models unless you opt into it, which is kind of good news for us as in-house lawyers because it's less negotiation that we have to do. Another aspect is retention. There is risk to the models retaining the data that you're putting in as input, and you may be successful in negotiating zero retention, meaning that the model is only going to retain the input as long as necessary to generate output, and it shouldn't be retaining it for longer than that period. So those are two things you want to think about AI specific when negotiating. I think because of the unknown sort of regulatory landscape, the unknowns when it comes to IP, having like reps and warranties that the way these LM providers have developed and provisioned their models is in compliance with applicable law, rule, and regulations, sort of those standard rep and warrants we see, making sure that they have the right licenses to allow us to use the tools the way we are. You think about the New York Times case where they, sued OpenAI for using their content. As a user of the output, you don't want to be subjected to a third-party infringement claim. So you want to be thinking about those types of rep warranties, indemnities for ownership. You want to retain ownership of your input. You likely want to retain ownership of your output. Maybe it's proprietary. Maybe you're putting proprietary information in and getting proprietary information out. Luckily, there does seem to be an industry standard where the LM providers are saying, you own output, I assign you the rights to output. So again, something hopefully we don't have to spend much time negotiating. But I think those are some of the key sort of AI provisions you want to think about.
Chanu, do you have anything you wanted to tack on to?
No, that pretty much covers everything. I also just want to, the standard clauses of like termination, because and suspension are quite important if you're building and stacking and using these AI systems on a regular basis, like making sure that you get advance notice before they cut you off and functionality just like terminates automatically at a certain point. They're on a lot of these LLM providers have a very LLM provider friendly set of terms. What I've seen is it takes a lot of power to negotiate these terms. Like you must either spend a lot with them, just like anything else. So those are some of a few additional considerations to look into when you're actually negotiating with the LLM providers.
Great, thank you for that. I don't know that we're going to get to a Q&A, but the questions I'm seeing in the Q&A seem to be getting answered by the panel, so I'm happy to say it. Haley, do you have something else you want to add?
Yeah, I just wanted to add one thing that I forgot to mention. I think it's important too when you're, if you are negotiating a contract, and maybe it's not, you're not contracting with OpenAI or Anthropic, but you're contracting with a smaller LLM provider that satisfies more of a focused use case based on a specific subject matter where you have some negotiation power, making sure that your inputs and outputs are categorized as your customer data. So they're being afforded the same protections as the standard data that you would give. So, confidentiality, all those things are now being applied to your input and output. I think is a good contracting tip.
Great, excellent points across the board. Okay, I want to turn now to evaluation and implementation, sort of a vital thing. Now, we say you should use it. Look at the risk. Now you do. So how do you put these things in motion and how do you evaluate them? Ashley and Julian, tell me when you need me to share my screen and I'll do that.
maybe I'll start at the high level and then Ashley will deep dive with the slide. But the one thing I will mention is that the evaluation part is very challenging, at least today, because these models are so different, and then the tools that are built on top of those models are so different. It's all brand new. And what makes it even more challenging is the fact that the tools and the models get updated almost daily or weekly. So whatever you've tested today may not be appropriate in a month. There are multiple sort of scientific evaluation techniques, which I'm not going to go into, where you basically have specific accuracy scores that you can calculate from of the responses. But a lot of it is really just sitting down with subject matter experts and kind of running different things, different queries, different prompts, and see what the responses look like. But you need a subject matter expert, because otherwise you'll be stuck in this sort of a potential hallucination hell where things just come back and they look real, but they may not be. So you need that expert as well. The one other thing I want to mention, that the thing related to a previous conversation, is that, just to clarify for everyone on the call, when you purchase or you negotiate with a legal technology tool, you basically have these two vendors that you actually work with. The vast majority of legal technology providers do not have their own large language model. So they may be using GPT. So you are negotiating with vendor A, but they actually have a contractual agreement with OpenAI as well. So you need to be clear about what that agreement says as well. So most of the time, you will not be negotiating with OpenAI. You will not be negotiating with Google. You will be negotiating with a specific technology vendor that solves a particular problem using Gen AI. So it's an important point to keep in mind.
It's like in-house gospel. Never forget the sub. Okay,
Yeah.
Ashley, over to you.
Yeah, I definitely agree with that, making sure that you're kind of going through both all the trail of the contract and terms and whatnot. But back to what Julian was mentioning also during the use cases, I just envisioned that the implementation is not much different from a legal technology implementation, aside from all of these risks and kind of unique use cases that we're coming up with, because it is a new technology. And so having said that, it makes the ideation stage, and you can throw the slide up. It's not, super, effective necessarily, but it's just a nice visual, I guess, that, thank you, Jill, for, the fact that the highest impact that we're trying with the least amount of effort is what you probably want to prioritize. So the first step is ideation and coming up with the use cases and confirming, which is somewhat equivalent to what you were saying, Julian, is in terms of the problem. Like, what is the problem? Well, what use cases can we either address as a problem, or which use cases can we become more efficient with? And so that's really what I think the two buckets of areas that we're trying to do here with creating and the use cases. So the ideation stage is critical, because you can go to all your stakeholders internally and say, what problems, what pain points do you have? And how can we use this new Gen AI to potentially solve that? So you're going to come up with possibly hundreds of use cases, very tactical, but also very large, like big picture. So then you have to go into prioritization mode. What is something that's a kind of a low-hanging fruit that you can implement fairly quickly, that might be in a tool that you already have, that you can just add on? And then you kind of go through the regular project management from that. You're vetting the various tools that are available, you're testing it, you're going through UAT, you're going through implementation and deployment. And then again, the repeat and iteration, this is going to be constant. It's not just project management driven with any legal tech. It's with Gen AI specifically. You're constantly going to have to be iterating because it's moving so fast. So that's, I think, to borrow a talent management strategy, the buy, borrow, build applies to this whole concept. How am I going to apply any of these tools? Am I going to buy it? Am I going to borrow it? Or am I going to build it internally? And so that's just another concept within the project management that I would apply to implementing any tool like this.
Great. Julian, anything further to add on any of this topic?
No, I think we got it.
Okay. Great. Last question of the afternoon, and I have an answer to my own question, but I'll put this out to the panel as well. How do you expect AI to impact the workforces for legal departments? I think we'll have Ashley maybe take a first run at this one.
Sure. I think I mentioned earlier, I think at the task level, we're going to see people just working faster and more efficiently. But it's also going to impact, it's going to continue to shake out over the next couple of years at the department level and the teams adopting and implementing all these different opportunities of AI. So I expect it to shift and to include whole departments being formed around the use of AI, the governance, the applications, the management, and the use cases. And these jobs will be dedicated to the expertise and data management of the LLMs that you've either contracted with or the tools that are using the LLMs. Many even that are like not technical roles where you're going to be required to have experience with prompt engineering and making sure you understand the use cases and where you can use it and where you cannot or should not use it.
I'd also like to mention that there's been a constant question from like law students that says that where they ask like, I'm getting worried about AI taking over like first year to like third year associate jobs, right? Of researching, writing briefs, writing kind of memos on these things. And they kind of ask for advice, and to which I'd say like what's valuable with like legal counsel is the decision making, the creative solutions. And what I keep telling the students is like distinguish yourself from just like the research component, the like the data analysis component, but more so like what type of leadership capabilities, what type of decision making capabilities, what type of nuance analysis can you like draw from these conclusions, as well as like creative solutions. And I think that's where you set yourself above like some of these AI systems where, you know, this job security, job protection, right? So.
Julian, any on that topic more?
At a high level, I don't know. I don't know exactly how it's going to impact. I think we know there's some efficiency gains that we're going to get, and that's that's been proven. But long term, depending on how these technologies improve, they may have sort of a more dramatic impact on the industry. But for now, and I know people are concerned about job security and things like that. I think those concerns are overblown. These tools will not replace jobs. They will help us be more efficient with tasks. And there's this whole thing where, technology today cannot beat humans, but a technology with a human will be the technology without a human without technology, right? So that's kind of that's the important element here.
Excellent. Okay, well, I have two objectives as it relates to the end of this webinar, ending on time and ending on a high note. So I'm going to attempt to do that now. To add to the points we just made, I think if you go back through this presentation today, if you think about all the topics we hit, I actually see a ton of potential for human involvement and achievement at each of these points, and actually think that AI is not going to work unless humans are involved at various points. And I think it's going to create new opportunities from a job perspective that we can't even really conceive yet. So that I didn't vet that opinion with any panelist. So that's not only in the opinion of my employer, it's not in the opinion of any other panelist, but I did want to end on that. So with that, I wanted to extend my thanks to Julian, Chanu, Haley, Ashley. It's been a phenomenal presentation. So much food for thought. I hope the audience feels the same way in terms of the takeaways. I wanted to thank Jill Brown, Steve Harbor at Cimplifi again. If you want to talk about this more, my email is on the website. Go find me out and we can chat about it out in the world.